Chief Justice, Justices, I'm acting for the Canadian Constitution Foundation, and it is my client's position that there is no constitutional right to strike under Section 2D of the Charter. I propose today to address two issues, though. The first is the issue raised this morning by Mr. Arve, that namely, if there is no constitutional right to strike protected by Section 2D, can't legislatures just prohibit strikes? And then the second issue that I intend to address today is the question that Justice Cromwell raised before lunch in relation to the Trade Union Act and the fact that it defines a strike as a cessation of work by employees acting in concert in relation to work, and if that's so, how does that not engage 2D? So those are the issues that I'm going to deal with. But both issues really run in to the fundamental question raised by the Chief Justice this morning, and that is, how does one define the right to strike? And really, everything that we've been talking about today is about that one point. So taking Mr. Arve's submission that can't legislatures simply prohibit the right to strike, that submission, in my submission, is an oversimplification, because it goes right to this question of what is the right to strike. And on the appellant's side, the submissions that you've heard today are all about the right to cease working. And I don't equate that to the right to strike. The right to strike is more complicated than that. The right to strike is something that is not a label. It is not a slogan. It is something that comes out of statute. And so the interorum argument about prohibiting strikes really could be said another way. It could be said that if there is no 2D right, then what that means is that governments can force people to work. That's the flip side of that argument. And that's simply not true. It's not true under the common law, and it's not true under our Constitution. So this legislation in this case...
Well, there was a time in the history of the common law where people could be sent to Australia or other places for having engaged in a strike because they were dealt with by the state as if they were illegal acts, contrary to the criminal law.
Yes. Well, our current legal system, though, in terms of how it handles employment relationships, deals with it pursuant to contractual principles. And absent labor legislation, there is no common law obligation to work. Specific performance of an employment contract is not going to be ordered in this country.
Well, the question that had been put was not that one. Would it be possible for the state to prohibit strikes?
And my submission would be no. It would not be, because it's not supported by the common law. It's not supported by the Constitution. And so I would say that on two bases. So if strikes were prohibited, meaning that someone needs to work, then someone would be able to claim a Section 7 right, life, liberty, and security of the person. Equally, 2D itself would protect an individual or workers from forced association. But the case that we're dealing with is not about forced association or forced work. The issue is, when work is withdrawn, what are the consequences for the workers? What entitlements do they have? And what is being sought by the unions in this case is not the naked right to withdraw services. It's the entitlement to the full panoply of rights in the legislation. And that's really what's going on, including the right to reinstatement, the right to continued benefit status during the currency of the strike, the right to a dispute resolution mechanism. So we're not talking only about the right to withdraw from work. We're talking about the full regime. And so we're not here today really dealing with the question of, is there a naked right to withdraw services? That's not the issue. And when we look at the legislation in this case, dealing with essential services, that's not the consequence of striking down this legislation. It drives you right into the Trade Union Act. And this brings me to my second point, which arises out of Mr. Justice Cromwell's question. So,
I just want to
yes.
make sure I'm not really clear on what it is that you're saying. How would you define a right to strike?
The right to strike is a complex panoply of entitlements and benefits and obligations as set out in the legislation in the various provinces.
Is it at the very least a right to withdraw services?
It includes that, but it includes it in the statutory sense.
And if that's the case and you took away that right to withdraw services, aren't we back to the common law where somebody who withdraws services can be dismissed?
Somebody could, if there were no right to strike in the statutory sense, then somebody could be dismissed, yes. So if there were no Trade Union Act, as an example, the person could still withdraw services. No one can be forced to work. They could withdraw services, but they wouldn't have any of the benefits of that, and they could also be terminated by their employer. So when Mr. Justice Cromwell asks the question in relation to the Trade Union Act earlier this morning, the Act does say that it defines a strike as a cessation of work by employees acting in combination or in concert in relation to work. And the question is, how is that not association under 2D? And first of all, I'd observe that that definition of strike is right out of a Wagner Act piece of legislation. And in my submission, you cannot just take the definition without taking the rest of the package. And so when we talk about what is the right to strike, it's not
well,
just
I guess that even before the Wagner Act, this kind of general description was pretty much what was described as a strike in the field of labor relation. You stopped working in common in order to gain some benefit or to prevent something.
I understand. And so that's a definition of strike within a legislation that includes many other things. And so that's my point, that you can't just take the definition. You have to look at the whole panoply of rights and entitlements and obligations.
But we didn't do that in the health services case, and we didn't do that in Fraser. We said there's a right to collective bargaining, and we left the modalities case by case. Right. So isn't that really all that's being sought here? The definition of a rights to strike as the cessation of services in a particular context. This is an interorum argument. If you give the right to strike, what you're doing is you're creating all kinds of statutory benefits, and that certainly hasn't been the way our jurisprudence has evolved. So looking at it simply as the right to stop services, what's wrong with constitutionalizing something that's in every labor relations scheme in the country?
What's wrong with it is that it's inconsistent in my submission with what you did in Fraser and in health services, and in particular paragraph 47 of Fraser. So my submission would be that Fraser is inconsistent with the constitutional right to strike in the sense that you've just described. The essence of it is that Fraser delivered, in my submission, a limited or modest, as the court said, entitlement to collective bargaining, and it did so on a procedural kind of basis. The rights that we're talking about here are substantive. And so that's why I say you have to look at the whole panoply of rights. So the right to strike in this context is not just the right to withdraw services. It's the right to all of this regime, because what you're fundamentally doing is you're changing the relationship between employer and employee. And all of these entitlements, in particular the right to reinstatement, is a crucial one in this context. That's not something available at common law. And so when a union in this context says we don't want to be we want to be able to strike and we don't like the essential services legislation that's being offered, but they're not saying we just want to be able to withdraw our services. They're saying we want to do that, and we also want to have these entitlements. That's the issue. And so those are substantive entitlements. They're not procedural. And they go beyond what this court recognized in Fraser. And so when we look at paragraph 47 of Fraser, which has been referred to before, this court made it very clear in rejecting the view of the Ontario Court of Appeal that legislatures are not constitutionally required in all cases and for all industries to enact laws that set up a uniform model of labor relations, imposing a statutory duty to bargain in good faith, statutory recognition of the principles of exclusive majority representation, and a statutory mechanism for resolving bargaining impasses and disputes regarding the interpretation or administration of collective agreements. And so what's protected is associational activity, not a particular process or result. That's the key to Fraser in my submission. And if it's shown that it is impossible to meaningfully exercise that right, then it can violate Section 2D of the Charter. We don't have that here. That's not this situation. It's not about the withdrawal of services only. The concern in this case is not that some legislature is going to say that employees in this country need to continue to work regardless. That's not the issue. You're saying you'd be okay with the right to strike as long as it didn't involve the right to go back to work after the strike? The issue is the consequences that employees face when they choose to withdraw their services. So under common law, they could be terminated. Under a labor legislation, they can be reinstated and they can follow that regime. So what applies or what consequences they see depends on what's going on. But in this case, so take the essential services legislation in this case. That legislation doesn't call for the termination of those employees. If they violate the Act, they can be fined. So it doesn't go further than that. So the employees who are declared essential need to adhere to the Act. If they don't, they receive a fine based on the days that they do not work. So
could you just explain to me what you mean by the government can't force people to work?
The government cannot actually compel somebody, so prohibiting a strike is not equivalent to saying that the employees are not allowed to leave, that they have to perform their employment. This is not specific performance of any employment arrangement.
What would you call a back-to-work order?
Well,
signed many of them, and everybody went back.
Yes, but people can choose to go back, and certainly employees can choose to go back. So if you're declared essential and you choose to adhere to that, you can do that. But if you choose not to, that's your choice. And there's no
if you don't want to spend the weekend in the detention center, it's your choice.
Sorry, I didn't.
If you don't want to go to jail for the weekend, it's your choice. I mean, I'm just not understanding this at all.
No, but if the state is compelling you to go to jail, that's a very different issue. The question is what your choice is.
There can be injunctions, contempt of court, and in such situations, even in some of those back-to-work law, you're left with very little freedom not to return to work.
The individuals can choose to not work. They can leave their employment. They do not have to stay in.
Choice is a very difficult issue that permeates many areas of the law, and it's found its way into this hearing, much to my astonishment. But there we are. I think your time is up.
Thank you very much.
Mr. Craig.